First off, I want to say happy Friday to everybody, and welcome to our presentation on, first, we're going to have Judge Phillips update us on the state of the courts, and then we're going to be discussing the new Supreme Court order adopting a new Rule 1.510 and moving to the Celotex standard for motion for summary judgment. So I thank all of you for spending your lunch hour with us. ABOTA appreciates being here. I hope that you will also rejoin us on Monday, on May 3rd, where we're going to be having another presentation talking about the new case management directives pursuant to Judge Tudor's new order that was, I believe, signed today. That order can be found on the ABOTA Fort Lauderdale website, www.abotaftl.org. We're going to be having a wonderful presentation with the Broward County Bar Association, where Judge Tudor, Judge Carol-Lisa Phillips, and Judge Robert Lee will all be discussing this new case management directive order and how it's going to be changing the landscape of the resumption of civil jury trials. So I want to first introduce our wonderful panel that we have. We have 3 members of the judiciary and 2 practitioners as well, who are going to be discussing this particular topic with us. First, we are delighted to have Judge Raag Singhal with us, who currently serves on the United States District Court for the Southern District of Florida. He was a judge here in our circuit, both in the criminal and civil circuit divisions from 2011 to 2019. He began practicing in civil after graduating Wake Forest Law School at Fleming, O'Brien, and Fleming, before he became a prosecutor here in Mike Satt's office for about 3.5 years, before going into private practice in criminal defense for about 18 years until he ascended to the bench. We're very happy to have Judge Singhal here, who was the recipient of the Friend of the Bar Award in 2019, the Stephen Boer Award as well. And he's going to help give us some perspective dealing with both summary judgment standards. We also have the current administrative judge for Civil Circuit, Judge Carol-Lisa Phillips, who is the reigning ABOTA Fort Lauderdale Jurist of the Year and also recipient in 2009. She currently serves in the Circuit Civil Division. She is past president of the Kiwanis Club, Fort Lauderdale. She's on the board of Hospice 100. She's a supporter of Handy and is on the Ethics and Professionalism Committee of the American Bar Association, as well as the Committee on Professionalism of the Florida Bar Association. And is an avid supporter of ABOTA, and we're very happy to have her as well. In addition, we have Judge Jeffrey Levenson, who is the 2019 ABOTA Jurist of the Year. He went to undergrad at Johns Hopkins University, went to law school in University of Maryland School of Law. After that, he was a prosecutor for the United States Department of Justice in their tax division, prosecuting white-collar crime. He then was an assistant United States attorney for the Southern District of Florida, and was is a current judge in the Civil Circuit Division. Prior, he was in the Extended Trial Unit for the Criminal Circuit Division. He's on the Code and Rules of Evidence Committee. He's the current Judicial Liaison for ABOTA. He's past president of the Federal Bar Association Broward Chapter and a current member of the Bench and Bar Committee. And thank you, Judge Levinson, for agreeing to be here to help us out. We also have our 2 practitioners who are joining us. We have Joe Kashi, who graduated from NYU Law School. He spent his first 20 years of his career with Conrad Sheard defending insurance companies. After that, he spent the next 20 years representing people who were victimized by insurance companies. And really, can't say enough about Joe Kashi. He's been fantastic for me as a mediator. He's been fantastic as co-counsel. He is a fantastic educator. I read his weekly law updates. They're excellent, and I encourage everyone to do that. He's been listed as Best Lawyers in America for the last 35 years and is a prior winner of the ABOTA Professionalism Award. So thank you, Joe, for being here as well. We're also joined by Andy Harris, who is board certified in appellate practice. He started his career as a judicial clerk for Judge Robert Gross at 4th DCA. He then was a partner at Burlington and Rockenbach. He was there for 13 years before leaving in 2020 and forming his own appellate law firm, Harris Appeals PA. He's on the executive board of the Palm Beach County Justice Association, where he frequently writes and podcasts as well. And he's on the board of directors for the Florida Justice Association, where he's the vice chair of the FJA's amicus group. So we're happy to have Mr. Harris here to discuss this with us as well. So I want to start off by turning it over to Judge Carol-Lisa Phillips to give us some updates on the state of the circuit and what we can expect going forward. So Judge Phillips, I will turn it over to you.
All right. Thank you so much, Brent. And thank you for everybody who's here today. This speaking engagement, as well as Monday's speaking engagement, are very important because we will be giving all kinds of information to give you a courthouse update. Happy Friday. And I think everybody will be happy to hear that we will be having jury trials, civil jury trials beginning in June. And jurors will be returning to the courthouse. And we have come up with a plan to socially distance. And what we've done is we're arranging it so we have 3 judges on each floor, 14, 15, and 16. So 3 of the judges will be trying cases, let's say the 1st and the 3rd week of June, and the other 3 judges will be trying cases the 2nd and 4th week of June. And the jurors will be summoned on Thursday and Friday. Now, the first group of jurors for that first week, now I know June starts off and Tuesday is June 1st. So we're considering June 7th, the first week of June. So we will be having jurors come in on that Friday, June 4th. And if selected, we'll go ahead and do jury selection on that June 4th. And they will return on Monday to begin the trial for that week. The following week, on that June 7th week, on Thursday and Friday, June 10th and 11th, you will be selecting jurors to return for the June 14th week. And then on June 17th and 18th, which is Thursday and Friday, you will be selecting jurors for the June 21 week. And the same goes June 24 and 25, the Thursday and Friday, we'll have jury selection for the week of June 28th. That way we can bring the jurors in and not conflict out, and criminal will be getting jurors on Monday, Tuesday, and Wednesday. And so we were able to gather those jurors for the Friday and then the Thursday and Friday for the following weeks. And again, we'll be rotating out. So we will have the ability, almost all of us, and I think every single one of us will, the adjoining courtroom to our courtroom, the way we tried to space it is so we will be in our courtroom and we will have the adjoining courtroom so we can use that as a jury room. So the jury will be able to socially distance within the courtroom in order to decide the case and go in there when we have lengthy sidebars and so forth. The jurors also will be split up instead of all being in the box in the beginning. When we bring up the 20 or so jurors that will be selected from, we will have them spaced out within the jury boxes with chairs removed, as well as seated on the benches. We also are getting plexiglass in the courtroom So we were taking everything into consideration. We'll have the antiseptic pumps and so forth to wipe things down and keep everybody's hands clean. And certainly the requirement in the 17th Judicial Circuit Courthouse is that everybody's going to be required to wear a mask. So we're taking all of those, the CDC guidelines into consideration and trying to do this as fairly and as safely as possible. But the good news is that we will be having jurors return beginning in June. And to hear more about it as well, we'll be talking about the case management in the coming up future. And I know Mr. Reitman already discussed this, but please attend the May 3rd program at 12:30, because it's going to be regarding how we are implementing the new Supreme Court administrative order regarding the case management. And if you go to page 16 of that new order in Roman numeral 3G, you'll be able to read about that, and we'll be letting you know how the 17th Judicial Circuit is implementing that Supreme Court order, as well as sharing with you the administrative order that came out today in the 17th regarding that CMC management, as well as an amended new uniform trial order for Circuit Civil and a new case management conference order for Circuit Civil, as well as Judge Lee is going to be talking about the county court case management orders that will be going out, and we'll be all sharing screen and you'll be able to see those. So it's very important, as well as today's program. And again, thank you all.
Thank you very much, Judge Phillips, for that information. We're all looking forward to what's coming up. If anyone wants to review the current order, again, it is available at the ABOTA website at www.abotaftl.org, where you can download it and take a look at that in advance of the upcoming meeting. Again, I want to just thank everyone for being here to support ABOTA, and I want to thank all our members of the judiciary who are here as well. We appreciate you. So to begin our discussion in talking about the change in summary judgment, I think probably the most logical place to start will be with Judge Singhal, who, Judge Singhal, you had the ability to experience both of these rules, I guess old 1.510 and then with your current post, you've been dealing with Rule 56, which has been largely adopted and will be replacing the old summary judgment rule. So I wanted to hear from you of your experience with both rules and some of the changes that you've seen in presiding over these matters.
Sure, and thank you, Brent. I want to thank you and ABOTA and Jeff Edelman and the whole group for including me in this talk here today. It's also really always an honor for me to be on a panel with Judge Carol-Lisa Phillips and Judge Jeff Levinson. They're two of my mentors, and really both had a big part in me being able to get to where I am today. And so it's just so nice for me to see them. I also want to really congratulate ABOTA for setting this up in such a timely fashion, because as we all know, the new standard is going into effect tomorrow, and we got guidance from the Florida Supreme Court just yesterday on how this rule will work. Up until yesterday, there was a bit of a conflict or a lack of understanding in terms of how was 1.510 going to look. People could compare it to Rule 56 in the federal system, but then yesterday, the Florida Supreme Court let us know, of course, that they feel that after taking comments and considering the issue, that the best course of practice is just to wholesale adopt Rule 56. Really, I think there's a little bit of history that's interesting in terms of summary judgment motions. If we go all the way back to the 50s, really the Florida courts were handling summary judgment motions similar to the Celotex standard, And there were a few cases that were out there, but they were slip and fall type cases. And then as we got into the 60s, particularly with Hull versus Talcott, the standard changed. And one thing that I think is interesting is it changed because there were two medical malpractice cases where summary judgment was seen differently. And maybe it was because the nature of the damages was far more significant than in the two slip and falls that earlier had set the summary judgment standard. And so in these cases, Hull versus Talcott and the one after, really we were dealing with catastrophic injury cases. And the Florida courts since then had handled summary judgment more in a way where cases would get to a jury. The arguments that deal with the summary judgment really relate to kind of two baskets of arguments. One is on the plaintiff's side, listen, if we grant summary judgment liberally, then it's infringing upon the plaintiff's constitutional right to a jury trial. On the other hand, really more of what's seen as a defense perspective is, look, if the case is going to end up in a directed verdict anyway, we ought to resolve it at the summary judgment stage because that will save the litigants time and money and really a lot of judicial labor. So Celotex came about in 1986. It's known as, I guess everything in federal is a trilogy, right? There's the Celotex trilogy, the Daubert trilogy, but this trilogy came about in 1986. And by right around 2000 or so, 35 states had adopted it. And Florida still, though, had a different standard, a standard where more cases got to the jury. I would really commend any of you, if you have the time, to read an article that Judge Thomas Logue wrote in 2002 with Javier Alberto Soto. It was in the Florida Bar News, and they together did a treatment back in 2002, arguing that the Celotex standard should be adopted. So they were way ahead of their time. But really, I think what we'll learn as we get into this more in the Florida court system is that the key to these summary judgment motions is whether meaningful discovery has been concluded. And the main difference that I've seen between state court and federal court is that the summary judgments in federal court are done when discovery is closed, there's no more discovery to be taken. If the lawyers want to take discovery, there's an order saying that motion for extension of time is denied. So it's really kind of an issue that's been put to rest. Whereas in state court, oftentimes summary judgment motions come in where there's an argument still to be made that, Judge, we haven't completed discovery. We need to do that. And really, I think that's going to be the key. It relates as well to the scheduling orders that Judge Phillips is talking about for Monday. And it relates to what Joe Kashi was talking about even before we started, that these federal rules, which have much more teeth and are much more strict, are now kind of being adopted to apply in state court. And is it viable? Is it going to be workable at the beginning? I think it's also critical that the Florida Supreme Court answered yesterday that any pending motions for summary judgment need to be ruled on under the new standard. So Celotex is in effect, even if there's a pending summary judgment motion that was filed a month ago, 2 months ago, yesterday, we're now under the new standard for everything filed from here on out and that's been filed and not ruled on up until today's date.
And so understanding, that certainly there's practical differences in the rules. When you transition from dealing with these motions to in state court versus federal court, in terms of the observations of practice, you mentioned that you were encountering motions that discovery had been largely completed. What other practical differences, you know, do you see in terms of federal motion practice that was different than state court that you think practitioners should know about?
Well, you know, I really think a lot of it has to do with how strict the rules are in federal court. Keeping in mind that I came from a state court judicial assignment where I was in criminal for 6 years and then went to civil. I got to civil in the state court system really being much more liberal in terms of the granting of extra time and continuances. As you know, Brent, from your time at the state attorney's office, oftentimes in those criminal cases, discovery comes up at trial, you know, and you have these things called Richardson hearings, right? And now all of a sudden you've got to stop the trial, whereas that's not something that we have in civil. But I had that mindset going into circuit civil in the state court system. And so I tried to be, you know, more lenient about continuances. You certainly don't want to get into Binger issues and things like that. Then I got to the federal bench, and I frankly was not used to how sharp the teeth were in the rules. You know, Rule 26, for example, in the federal system gives you timelines for disclosures and things like that. And it would really be a little bit sad for me to see a case that came from the state court system. It was removed to federal court, and you know, you kind of know who the lawyers are, and they're used to really litigating well in state court, but now they're up against this federal rule that they may not be as familiar with, and those teeth are so sharp in that rule that you can't give them the time that you might have given them in state court. And frankly, some of the lawyers may look at you because everything's decided on the papers in federal court. You don't get to have those hearings on many cases. And I can envision litigants saying, oh, okay, Judge Singhal will give us the time, but it's not me as much as the rule. The rule doesn't call for it, you know? So I do think the practitioners have to be very cognizant of these procedural rules and the timelines in there, because they're very strict.
Right. And I know that, you know, we've discussed it before, but in terms of the what the new rule sets up for the factual presentations, that I mean, would you say that at least dealing with factual disputes is a lot more streamlined when essentially there are factual assertions that happen that the other party has to respond to one by one?
Oh, I absolutely agree. I will tell you that in the federal system, we all have trial orders that go out right when a case starts. Included in that order is a lengthy section on summary judgment motions. And the section on summary judgment motions is 2 full single-spaced pages that talks about how to file a summary judgment motion, and specifically how the movement should state their facts, and how the respondent should write an opposing statement of material facts. Everything has to be pointed toward a record site. And in all candor, I can tell you, if I would have put this order out in my civil division, I think that numerous lawyers likely would have said, gee, I wish you would have stayed in criminal, because it's really a very detailed, strict order. But I think if the Florida Supreme Court is now saying we're going with Federal Rule 56, I would really expect that my state court colleagues would adopt this kind of order and set out some real rules in terms of how to state the facts, how to oppose the facts, and try to iron out, look, is there a genuine issue of material fact or not? And basically what the question then becomes is, are we in a situation where we know what the facts will be at trial, such that if I got to the directed verdict stage, are these the exact facts I'll be looking at? And if I'm going to grant a directed verdict at that stage based on these facts, then why shouldn't I grant a summary judgment now and save the litigation expense and time and all of those things? And so I think that's really what it boils down to.
Thank you, Judge Singhal. My next question I would like to pose to Judge Levinson. There are some parts of the rule that have been amended that probably were of frustration to some of the judiciary, such as the time for the non-moving party to respond and to file their summary judgment evidence 2 days advance of the hearing. And whereas the new rule seems to want to remove they called gamesmanship by changing the timeframes and to allow more robust argument for some of these summary judgment proceedings. Judge Levinson, are you happy about the new time frames, or what can you tell practitioners?
By a little background, I actually got on the evidence committee because I wanted to weigh in on the Fry versus Dalbert issue. But by the time I got on the committee, the Supreme Court already decided it. Well, I'm now on the Civil Rules Committee, and I wanted to try to weigh in on the summary judgment timing. Well, that's not necessary at this point, because if you look at the new rule, you got to file the moving party has to file 40 days before the hearing. 40 days, 40 days. And then the non-moving party, the responsive party, has to file 20 days before the hearing. I used to just beg people to file 5 days before the hearing. I would get responses 3 in the morning the night before. And you know what? I'm good, but I'm not that good. Okay, it's hard for me to be up reading that response that late at night. But this really sets up a process. But what Judge Singhal said is so fundamentally important. The timing has to be correct. So we use our time wisely. The timing has to be correct. It has to be when it's ripe. Because the last thing I want to do is have people come in and say, okay, we're not ready because we got all this additional discovery to do. Do it when the discovery is closed, but well before the calendar call. That's what needs to be done. One other point I want to make, though, we're always thinking about the defendant following the summary judgment against the plaintiff. But think about this. There's also summary judgments that are filed against the defendant and the affirmative defenses. So what's good for the goose is good for the gander. And that would also come into play. But in direct answer to your question, Brett, I am thrilled that, because I think like my colleagues on the civil bench, we take pride in reading and being prepared for the hearing. And it's just really hard when the stuff is provided so late in the game. So yes, I think it's a good move in that regard.
Are there any other parts of the rule or the new adoption of the rule or the change that you're looking forward to from a judicial perspective?
I like process. I like things to be organized. And that's what I like about this rule. It sets up a real specific process. As Judge Singhal had said, you know, we're going to be able to line it up. What I think is interesting, though, is the Supreme Court has been very explicit. Judges must make complete findings, explicit findings. You know, they want us to do that. And I am hopeful that maybe the Supreme Court will adopt the federal rule and provide each judge with 3 law clerks to assist us in that. But right now, I am my own law clerk for the most part. So that's going to be a real challenge. We're going to really have to be on our toes to be able to get it right in that regard. But I think that it's good that the rule clarified. We don't have to worry about when the motion was filed. We know now what the rules are that applies to everyone. And I think we're also going to get a lot of litigation because they also said if you want to have it reconsidered, they can file it under the new rule. So I think we're going to be having a lot of litigation coming up in that regard.
Right, there were some interesting questions that I received about some of the new timeframes. Actually, Stephanie Seraphin emailed me a question that I guess she has there's a motion for summary judgment that's pending, and it's less than 20 days from the hearing now that the new standard applies to that pending motion, and she doesn't have enough time to file her summary judgment motion. you know, what do people who are in that sort of, I guess, rare time bind do in that situation?
You know, from my perspective, I just say move the hearing. I think we need to comply with the rule. So we'll have to deal with it. I think that'd be the logical thing to do. We're going to have a lot of these hearings. But we want to definitely follow, we want to space it out. I guess the other question is, when is a reply? Maybe Judge Singhal, you can help us with that. When does a reply come in? If the moving party wants to file a reply, again, I hope that doesn't come in 3 in the morning before the hearing.
You know, I think a lot of it will depend on whether a reply is even necessary. And what we have done in the federal system is really limit the pages and the length of a reply, certainly not having it come in at 3 a.m. You know, one of the things in the federal system is we're under a time constraint, not just in terms of when we resolve cases, but each motion. And so, for example, if we were in the position that you're in, Judge Levinson, right now, where there's a pending motion, sometimes it's difficult to move a hearing, and then it shows that you took too long to resolve it. So probably what we would do in that situation is we deny the motion without prejudice, have them refile it, start new timelines again. No, I agree with you completely. And I know that it was partially a joke about the law clerks, but truly, you know, just to give the lawyers some information. So there are 90 judges that sit in Broward County in the 17th Circuit Court. There's a pool of, I think, 17 law clerks. Probably half of them do really criminal matters, and maybe half will do civil matters. But that pool, if you think about it, is stretched very thin, and it's across the board on every case. And so you'll have some judges that might use that staff attorney's office for 5 cases a year, and some that might use it for 100 cases a year. And so it's really not an ideal system to have where lawyers can help you with these summary judgment motions. So when you take the sheer number of cases and the sheer number of summary judgment motions and the lack of help, I think it's really a daunting task, particularly for judges in big counties like Broward.
Absolutely. In terms of the functional aspect of when this, you know, I guess in the next couple of days when this rule is in effect, is there any plan for any sort of local rules or divisional procedures to change to help, you know, as Judge Singhal suggested, to streamline the factual presentations, to get, you know, the actual procedure streamlined?
May I defer to Judge Phillips on that?
Absolutely. Thank you, Judge Levinson.
We have, since when we all got together the other day to discuss what we would be discussing here today, and Judge Singhal had raised that issue and the fact that they do have the forms that they require the parties to prepare and follow the deadlines. Judge Singhal was kind enough to provide a copy of that to me because we've been working on the case management order and the new uniform trial order and the new case management conference order. I haven't got to that yet because this one just came out yesterday, but we will be working on something to make it more structured and to put everybody on notice. So again, it's in order to give everybody a fair opportunity to be heard on the issue. And I think now with the filing that it must be filed 40 days before the time fixed for hearing, and that the non-moving party has to respond at least 20 days with all their supporting factual position 20 days before the hearing is going to be very helpful. And like Judge Levinson said, you know, we look at this stuff and we think we're prepared, and then we come to the hearing the next day and the counsel says, oh, I uploaded a reply this morning. Well, now I'm not prepared, and I've uploaded the supporting case law this morning, and so now I have to take it under advisement and go back And one of the things you asked Judge Levinson about with the new rule, not only does the new rule require, it says, shall state on the record the reasons for granting or denial of the motion for summary judgment, and it must be with enough specificity to provide useful guidance to the parties, or if necessary for appellate review. We also, the fact that it takes effect tomorrow, May 1st, it governs any motion for summary judgment decided on after that date, including pending cases. And it allows reasonable opportunity to renew if there's been a prior denial. So what have we been doing all year? We've been doing special set hearings, lots and lots and lots of motions for summary judgment. It says that it should be allowed if the motion, obviously we should follow the new rules if the motion's been filed but not yet decided. And if there's a rehearing, the other important component to that is if there is a rehearing on a motion that has already been heard, we have to follow the old rule with regards to that motion for rehearing.
Thank you, Judge Phillips. I guess I'll open this up to the rest of the panel. I want to have a little bit of a discussion about what the practitioner can expect moving forward. And you know, it's one of the substantial changes in terms of the previous rule to the new one deals with how you're able to meet your summary judgment burden, which the new rule allows you to point out that the opposing party cannot prove a necessary part of their case. So, what can we all expect on how to deal with the actual change in that regard?
Judge Rodriguez had his hand up, Brent.
Oh.
I just wanted to make a quick comment. One thing that hasn't been discussed yet is if you look at the administrative orders and if you look at the Supreme Court order, the order reads that it's going to be strictly, these time limits, including the one for the summary judgment, are going to be strictly enforced against the attorney. Now, the language that concerns me and gets my attention is that then it says it's going to be strictly enforced against the judge. And I always have that in the back of my mind, worry that I don't want it strictly enforced against me. So, you can expect the judge to have that in the back of their mind that, wait a minute, I've got this rule that says, 40 days and 20 days and they have to be strictly enforced. And, unfortunately, I've already noticed a bit of concern on my part on some of these hearings. And also keep in mind that now we're going to have motion calendar, special sets, and starting, on Monday, case management conferences on every case in our division as they're filed in the backlog. So we've got a time crunch. We sign orders, we draft orders, some orders, and then we're supposed to have jury trials every day. So we're under a time crunch here. So keep that in mind, and I want to apologize to everybody in advance for my new attitude. Thank you. So
it sounds like not very busy.
Brent, if I could just add in, and I don't want to make things worse from the state perspective, but sometimes we would have these motions for summary judgment, and the lawyers would say, Judge, I need 2 hours for this motion or 3 hours for this motion. And if you think about how this rule is set up, everything should be in the motion and the opposition. And so for that reason, in federal court, we don't have hearings on these summary judgment motions. So those special set weeks where in Broward, if you need a 2-hour hearing, it might be 4 months to get a hearing because there's, only so many blocks of time that you can use. I think that if there's really strict compliance with these rules, we may also be headed to either no hearings on these summary judgment motions, or maybe judges saying, look, I can give you a hearing, but both sides 20 minutes total and that's it. because I do think that it would be a little bit inefficient for the judges to sit there for a couple hours just for the lawyers to rehash everything that's in their detailed pleadings.
Absolutely.
Brent, you asked for the practitioner's perspective. I'd like to give you mine.
Absolutely.
What I'd like to do is I'd like to respond to what Judge Singhal just said. In state court, as opposed to federal court, there is a body of case law in which summary judgment can be reversed if there was not a hearing, because as a matter of Florida state law, as it presently stands, the parties are entitled to a hearing on a motion for summary judgment. One of the things I was wondering about before yesterday's order came out was whether that was going to change and whether we would move to a federal type system where hearings on motions for summary judgment are no longer mandatory. I think we have somewhat of a clue by the fact that the timing of the summary judgment corresponds with a hearing date. So at least for the time being, I think that the Supreme Court is signaling to us that we're still going to have hearings on motions for summary judgment, because if that were not going to be the case, you wouldn't have the 40 days and the 20 days based on the hearing date. So I think for the time being, we're going to have hearings. I do think that Judge Singhal is right, and the hearing time less hearing time will probably be necessary, because you're not going to be able to shoot from the hip on a motion for summary judgment anymore. And I think for those of us, I didn't think of it this way before, who have been fortunate enough to handle cases in both state and federal court, this is going to be less of a culture shock. But if you haven't handled cases in federal court before, it is going to be quite a culture shock for you. And when people would ask me about the difference between handling cases in federal court and handling cases in state court, I used to tell them that the federal practice is a much more austere practice, because there are definite rules and they're strictly adhered to, while the Florida state practice used to be more of a forgiving practice, so that if you were acting in good faith, but you didn't comply with a rule, the judges tended to be more forgiving. They give you, a second chance if, you were not blatantly ignoring rules. And I think what's going to happen, and I think the pandemic is largely responsible for this, because I think that that Justice Kennedy is very concerned about the backlog of cases, and he wants to try to get through that backlog as fast as possible. And I think that's the reason we're going to have these strict scheduling orders. And had it not been for the pandemic, I don't know that that would have happened, or at least would not have happened in state court as fast as it is happening. As a practitioner, one of the big differences for me in dealing with a motion for summary judgment in federal court is, in federal court, the judges get to weigh the evidence. In state court, judges could not weigh the evidence on a motion for summary judgment before. And the reason I say that judges get to weigh the evidence in federal court is, you will see that the judges will grant summary judgment because no reasonable juror would conclude that the non-moving party would be entitled to judgment. That's weighing the evidence. In state court, we didn't do that before. If there was any evidence, even if the judge thought that it was incredible, that would preclude a motion for summary judgment. Think about the case that led to the adoption of the federal judgment standard. It was a motor vehicle accident case. I think the plaintiff rear-ended a truck. The truck had a dash cam, and the certified question to the Florida Supreme Court is, can we grant summary judgment if the disputed fact is irrefutably contradicted by video evidence? And the Florida Supreme Court took it a step farther. They said, we're not going to make a limited rule. We're going to adopt the federal judgment standard. So we're going to apply this to all cases. So be prepared for that. The standard is, if no reasonable juror could find in favor of the non-moving party, then the moving party is entitled to summary judgment. Now, you know, we were talking, the issue came up about what is the timing of a reply to a motion for summary judgment. I don't know that we are entitled to reply to motions for summary judgment, because if you look at the new rule talks about the timing of filing the motion for summary judgment. It cannot be filed sooner than 40 days before the day of the hearing. And then when does the response have to be filed? It has to be 20 days before the date of the hearing. Because the rule does not talk about the timing of a reply, I think that might be construed as we're not going to have replies. And then what I would commend to people is to look at the local rules for the Southern District of Florida. And the local rule talks about statements of material fact. And I think that that you could look to that for guidance. I mean, in the absence of the courts putting in their scheduling orders or their trial orders, you know, detailed rules on how to present your facts, I think if you follow the federal rule, even if it's not mandatory, it'll be very helpful in teaching you how to respond. So one of the big differences in federal court is this. The moving party files a statement of material facts. Then the non-moving party has a certain number of days to respond to that statement of material facts. And in the Southern District of Florida, the statement of material facts is a separate document from the motion for summary judgment. That's important because there are page limits for the statement of material facts, and their time limits for the memoranda in support of and opposition to the motion for summary judgment. And if it weren't for being able to file a separate document, you might not have enough pages to adequately address the facts and address the merits of the motion. So, so that's very good. And I will tell you this, although there's some things about federal practice I don't admire, I do admire the procedural way in which the federal courts deal with motions for summary judgment. And the thing in particular that I admire is the statement of material facts, because if the non-moving party does not respond within the deadline to that statement of material fact, those facts are deemed admitted. So from my standpoint as a practitioner, one of the most important things I do, it takes me more time to respond to a statement of material facts, and it's more arduous than responding to the motion on the merits. And it's absolutely critical because the court looks at the statement and looks at the opposition, and that guides the court's determination of what the facts are that govern the case. And the interesting thing about the new Florida rule is the courts are not required to look beyond the submissions of the parties in determining what the material facts are. The court has the discretion. The court is not handcuffed. If the court wants to look beyond the submissions of the parties, the court has the ability to do that, but the court is not required to. And I don't think you want to assume that the court's going to look beyond the submissions, particularly when, you know, when the judges have told us how daunting their schedules are. So if it's not in the statement of material facts and it's not in the opposition to the statement of material facts, it's probably not going to be considered on the motion for summary judgment. Now, in the Southern District, the way it works is first you respond to the moving party's statement of material facts. And the first word you have to have is disputed or undisputed. And then if it's disputed, you have to explain why. Then if you're in the non-moving party, you get to add material facts that the moving party didn't bring up. You know, like if you think they left out things that are material, then you have to raise it. Now, Judge Singhal talked about the fact that in federal court, one of the nice things in federal court is the judge is not presented with a motion for summary judgment until discovery has been closed. Because in federal court, one of the first things you do is you have a scheduling order. And the court will direct the parties to submit a scheduling order by a certain date. And the parties provide the court with a proposed joint scheduling order. but it almost seems like that's a waste of time because it's like the court never pays attention to that. They come up with their own scheduling order anyway. So sometimes it seems like you're spending a lot of time and it doesn't make a difference, but it's nice to be able to give the court suggestions. When you get the scheduling order, it will have a deadline for filing dispositive motions. And that's, you know, we're talking about motions for summary judgment. The thing though is it's a deadline. It doesn't mean you're not allowed to file a dispositive motion before the deadline. It means you've got to file it by that date. Now, in the cases I've been involved in, people don't file, you know, motions for summary judgment, you know, months in advance of the deadline. They're normally complying with the deadline, but that doesn't mean it could not happen. You know, particularly in state court where there's less experience in dealing with the federal summary judgment standard. So conceivably, even if the scheduling order has a deadline that is after that is after the discovery cutoff, you could have a party filing their motion beforehand. But the rule gives the court the ability to, you know, to deny the motion or to postpone ruling on the motion until later. And I would not be surprised if judges do that and we have the ability to wait until after the discovery cutoff before, you know, considering those motions. Those were the main points that I was thinking about. Brent, do you have any questions, you know, like you'd like to ask me? I think you're muted, Brent.
Sorry. Yeah.
Hey, Brent.
Thank you, Joe. Yeah, just Judge Levinson.
I just want to follow up on what you said, Joe. Joe or Andrew, when you guys argue before the Fourth DCA in a case that involves, it's something that involves a whole trial, how much time do they give you to argue?
20 minutes.
Okay. I get requests all the time for 2 hours for a summary judgment. 2 hours. Okay. So to me, if we all follow the rule, there is no reason why we cannot have the hearing no more than 30 minutes, maybe even 15 minutes. Okay. The other thing is what's been common in the cases up to this point is we'll get a motion for summary judgment. And the only response that I will get is an affidavit. I don't even get a memo of law or anything of the sort. So I think this is going to be a culture change. You have to actually write something down. You have to actually do the exercise. So we all go through it together. And I think it's going to make a meaningful difference in how these cases are litigated and how they're resolved. And make no mistake about it, we're not our job is not to close the courthouse doors for people that are filing lawsuits. What we're trying to do is make it so it's more efficient. Because if you're going to file a lawsuit and we let the case go through, and I've done this many times where I've denied summary judgment, and then the case goes through and it's either a directed verdict or more likely a defense verdict. So what happens is we've wasted all this time, money, and it's almost like saving the moving party for themselves. So I just think this is going to be really helpful to crystallize the issues. But we're not predisposed to granting these things. We're predisposed to make sure that we get to the right result.
So, Brent, go ahead, Joe.
One of the things I was just thinking about is, actually I've been thinking about it for the past week, that adopting the new federal summary judgment standard and adopting the new and the new scheduling orders may help reduce the federal court diversity caseload, because litigants may no longer feel that it's important to remove cases to federal courts as they do now, because as the state practice mimics the federal practice, the feeling that we need to remove cases to federal court may diminish. And I don't think that's going to happen immediately, but I wouldn't be surprised if after a year or two, it would be very interesting to look at the statistics and see if removals become less frequent.
So my jumping in from my perspective as a practitioner, I actually feel even stronger than Joe. I think the plain text of the rule does not allow for replies, and my position will be just that. When I file, now I represent on the plaintiff side, and as Judge Levinson said, what's good for the goose is good for the gander. But when I file motions for summary judgment, I'm going to take the approach, this is our one shot on behalf of the moving party. Because I think the Supreme Court here, if they wanted to allow for reply, we don't know, they would have said it here. They had a lot of comments that came in. There were comments addressing replies and whether those should be allowed. So that's going to be my approach, but only time will tell where the courts come from there. One important part of the rule, which it mirrors Rule 56, I just saw this played, unfortunately, in a federal case. In that case, discovery, and on behalf of the plaintiff, arguably, and I haven't got into it, it looks like the defendant moved for summary judgment, one could say prematurely, before the plaintiff had the opportunity to develop all discovery. But what the plaintiff in the case didn't do, which is what's in Rule 56, and it's now exactly here in our new rule, is the plaintiff didn't submit an affidavit or declaration to the district court judge and say, discovery is incomplete here, and this is the discovery I need. So what happened is there was no hearing. The plaintiff filed a response which was not sufficient. The trial court granted summary judgment. I think properly. I told the trial lawyer, I think properly. They now want me, the plaintiff now wants me to file a motion for reconsideration and tell the federal district court judge, this is not you, Judge Singhal. This is not a case of yours. Judge, discovery was incomplete. Here are the 4 witnesses we need. Well, so I think, for our practitioners, like Joe mentioned, for the folks who are not federal court practitioners, it's going to be a sea change. The rule has teeth here. I don't think that motion for a hearing, I'm not going to file that motion for a hearing. I can't do it in good faith. I told that to the trial lawyer. I've got other arguments to make as to why summary judgment, go have it with the 11th Circuit. But so that's an important part, an affidavit or a declaration that the non-moving party has to submit to the trial court with specificity. And so I think that's a really important thing. One other thing, I know the question was, oral arguments. Judge Levinson asked about oral arguments at the 4th District. Well, it's really hard for me in summary judgment cases to tell the 4th District why I should have oral argument in a case. To be very frank, when I first started practicing, I had a standard form, from the office. Oral argument is needed to clarify the issues in the record because of the complex issues, right? And I figured out pretty quickly, and I had clerked at the 4th, we're really insulting the judiciary to say that oral argument is needed to clarify the issues in a summary judgment. Now, it's one thing, a 6-week jury trial. But so now I really have to go out of my way when I request oral argument at the 4th to try and give them a reason in these summary judgment cases. And my experience, they're granting fewer and fewer oral arguments for motions to dismiss in summary judgment. And it's reflective of what Judge Levinson says and Judge Singhal in the federal system. What more do we need here in oral argument? We're only supposed to rule on the papers. There's a line of state cases where parties don't have court reporters at summary judgment hearings. And, you go, well, we need a court reporter at a hearing, not technically under the old rule 1.510, and certainly not under the new rule, because there is no evidence to be taken. Now, you still should always have a court reporter there at the hearing. I would suggest you always should, but in theory, that court reporter is not necessary. And now, especially because the judge, and this is a burden on the judges are going, as Judge Phillips mentioned at the beginning, judges are going to have to explain their reasoning, not just in granting summary judgment, but in denying summary judgment. Now, as a practical fact, there are very few orders denying summary judgment that can be immediately appealed. But with that said, judges still have to follow the law, and it's right there in the text of Rule 1.510. So every order denying summary judgment is going to have sufficient findings to facilitate appellate review. And parties can, after the end of a case, if they can't immediately appeal an order denying summary judgment, which is the general rule, there are certain exceptions like sovereign immunity, workers' compensation, things like that. But parties can appeal orders denying summary judgment at the end of a case. There's a couple DCAs that have issued conflicting opinions, but that can happen. And so I think for the trial judges, I feel really, really, really bad for the judiciary here. Our state court judges, you know, I clerk at the Fourth. Judge Singhal has 3 clerks, right? You all at the judiciary have nothing, or you have limited central, or you have central staff or whatever. This rule is going to be great for business for me in a sense of people are going to need me more. But I don't take that with pleasure or happiness, but that's the reality, that it's going to require a lot more work for our practitioners from the plaintiff side. You know, a lot of the plaintiffs firms, 1 lawyer firms, 2 lawyer firms may not have the resources. So a lot of what we've seen in the past about parties filing responses 2 days before or arguments, I would, not that anyone here suggested that it's been done in bad faith. I'm not suggesting that at all, but a lot of times it's the reality of the system where lawyers may not have the resources on their own. They're going to have to get accustomed to it, no question about it, under the new rule here, with the procedural aspects for those who have not been in federal court. So that's my practical.
Andrew, you know, I think it's going to be, even if you can appeal the denial of a motion for summary judgment after the case comes to an end, I think it's going to be very difficult to show harmful error, because what the Florida Supreme Court is saying is that now the summary judgment standard is identical to the directed verdict standard. That is one of the sea changes that the court has created here. And if the standards are the same, and then how do you say that there was harm? And not only that, if the motion for summary judgment is decided after the close of discovery, how can you show harmful error? Because you're not going to be able to put in more evidence at trial than was discovered. So it's not like some new fact comes to light at trial. And since the standard is exactly the same, if you don't get the directed verdict, then you wouldn't have been entitled to the summary judgment. So it's difficult for me to conceive of a situation, and I'm sure there will be one, but I think it's going to probably be few and far between, where you'd be able to show harmful error from the denial of a motion for summary judgment. What do you think about that?
I agree with you. I agree with you. It's just that trial judges have a duty now under the rule to give not just an order of denial or for the reasons stated in the record. And so for our state court judges here, in a typical auto accident case, an order denying summary judgment is not immediately appealable against a private, non-sovereign immunity defendant who. So judges still have that duty to, whether it's 1 page or 5 pages, and are they going to, so they still have to do it. But I agree with you practically that there are very few instances where summary judgment would be denied correctly, but directed verdict, the directed verdict result should mirror, except as we know, sometimes things happen in trial and witness testimony isn't exactly what it was in deposition testimony. And so although the evidence should be the same, sometimes it's just, things can change. But I agree with you, there's going to be very few practical scenarios in the typical cases where orders of summary judgment are later appealed successfully.
Real quick, I know we're running out of time. Can I ask the 2 practitioners one quick question? Would you rather the judges rule from the bench with detailed findings or detailed ruling? Would you rather us take it under advisement?
Go for the bench.
Joe, I'll defer to you first, but I can speak.
Why don't you go first, Andrew? What you have to say?
So, I tend to get it. People hire me because the cases are typically complicated or more complex, because otherwise in the personal injury cases, they don't. So I'm always a fan of not ruling from the bench and letting me go back and submit a proposed order based on the hearing and have it teed up for a proper appellate review. And also the practical reality of the state circuit court judges, we may have 15 minutes. So I'm a proponent. Now it requires more work, of course, to go back, and it's easier from the bench. But I also think because of the rules requirement that you have to facilitate appellate review, if I were a circuit court judge and you've got 3 hearings that day, me personally, I'd want to have the parties.
Yeah, but didn't you just say that the appellate review for denying it is rather limited, and for granting it, it's de novo. So I don't understand what's the point? Isn't it de novo review?
It is de novo review. There's some case law in our state courts where judges have said, I grant, you have where there's been a 3-hour, in reality here where we've had a 3-hour hearing, right? And you have a 3-hour hearing and a defendant brings 6 grounds for summary judgment. And the trial judge at the end says, granted for the reasons stated on the record, In the appellate courts, there's a couple of opinions they've said, sort of, not snarkily.
But Andrew, it's a de novo hearing. If I do an order, it's not given any weight. They decide based on the record anew. Isn't that correct?
You're correct on that, but there's a whole line of, as an appellant, if a defendant brings 6 grounds for summary judgment, right? It matters for an appellant from a briefing perspective if you've disagreed with 5 of them, but only adopt issue number 6. So for me as the appellant, I'm not going to address I may not address all 6 if you have denied it on all 5. And so for me, I like to know from the trial.
So you want us to say we denied on all 5?
Well, I'd like you to say you denied on all 6, representing plaintiffs.
Yeah, all 6. Yeah. Anyway.
Well, in seriousness, yes. I think. I'm sorry, someone else is speaking. Go ahead.
Andrew, what I was going to say is the problem with what you're saying is the right for the wrong reason rule on appeal. So let's say the judge denies the motion on 4 grounds, grants it on the 5th ground. The appellate court is free to say we're affirming, because the judge should have granted it on grounds number 1 and 3. Actually, the judge was mistaken in granting it 1.5, but we're going to affirm because it should have been granted on 1 and 3. So I think you've got to be a little bit careful, as the lawyer in ignoring everything. I guess maybe, and the problem is, do you say, well, I'll wait to see what they do in the answer brief and I'll address it in the reply brief. Are you going to be foreclosed, because you didn't mention it in your initial brief? You got to be you've got to be careful. There's a little bit of a dilemma here.
Joe, do you think we should rule from the bench or do an order?
This is what I think, and I know you, Your Honor, because you've told me you don't like to delay rulings. You like to get them out. If you think the issue is complicated enough that you've got to think about it some more, that you're undecided, then I certainly wouldn't want you to rule from the bench. But on the other hand, if you feel there's nothing that further examination is going to do to change your mind, okay, and you articulate your ruling with specificity, because that's what the appellate court wants. Even though they have de novo review, they want as much guidance from the trial court as possible to understand the rationale for your ruling. So if you do it with specificity and you're convinced that waiting is not going to change your mind, it's not like you have to reweigh things. And with your problems with your schedule, let me put it this way, I would certainly understand the ruling from the bench. I'm not going to tell you I would prefer it, but I would certainly understand it.
Thank you.
Just one thing.
I like the ruling from the bench.
Ruling from the bench.
I was told when I came to civil, the lawyers want you to rule. That's part of your job. Be prepared. Okay, I prepare up front. Listen, weigh both sides and rule. And but I know that Andrew, as an appellate lawyer, would prefer that I put it down on paper and put it in writing. But when we get a couple more, by the way, for everyone to know, we have an opening in the staff attorney's office. We were missing a staff attorney. So if you know anyone that's interested in becoming a staff attorney for the courts, we do have application. We have an open application time. So you're welcome to do that for a
By the way,
I don't know if they're going to be interested anymore.
As far as ruling from the bench is concerned, I want to share an anecdote with you. I have a case in federal court where I think by February 7th, all the briefing was done on a motion for summary judgment. It's a motion for summary judgment against my client. Every time in my email where I see something for the federal court, I almost throw up because in anticipation of that ruling. So one of the nice things about ruling from the bench is it puts you out of your misery.
So
Andrew, you had mentioned that this may result in more work for you. I think it hopefully will result in more work across the board, because really this rule is going to be a major problem for pro se litigants. And so hopefully some of these pro se litigants will go ahead and retain counsel. My experience on the state court bench is sometimes when a pro se litigant had a summary judgment filed against them, what would they do? They would appear at the hearing with their witnesses. And that's no longer going to be something that's at all in the cards. So will be interesting to see how it plays out.
I had a couple things I wanted to let everyone on know that we just circulated the CLE credit document, and if anyone is unable to download it from the chat where it was sent, you can email Jeff Abrams for it for the 2 credits for the appearance today. I want to open it up for questions. If anyone wants to type them in, we'll try and get a couple in. I wanted to follow up on one of Joe's comments. You mentioned that there is a body of case law requiring hearings or for motion for summary judgment, but that case law was an interpretation of the previous rule. There's a tremendous amount of jurisprudence from the previous rule that there's been some questions that have historically been left up to juries because of the complicated factual natures of them, such as the determination of proximate causation or agency questions. Is that all gone now with the adoption of the new rule and the new standard?
Brent, could you repeat the last part of your question?
Is all of that case law, such as requiring the hearings that was interpreting the previous rule, or the case law standing for the proposition that some questions are generally reserved for juries because of the factual specific nature of them, like agency and proximate causation. Are those bodies of case law, I guess, no longer good law in Florida?
Well, what's going to happen is if the judge determines on motion for summary judgment that no reasonable jury could find for the non-moving party on that issue, then summary judgment is going to be granted. And I just saw a question flashing across my screen. What is the new rule going to do for judicial discretion? I think it's going to increase judicial discretion, because before, if there was any evidence, that would be admissible at trial, that created a factual dispute, it was going to preclude summary judgment. Now the court has the discretion to say, well, I don't think any reasonable jury would find that way. And, whenever I think about that, about no reasonable jury would do this, I think about those directed verdict cases where you'll have a opinion and the majority will say no reasonable person could find, and then there's a dissenting opinion by one of the judges on the panel. So it's just sort of interesting what one person's conception is of what no reasonable jury would do may differ from judge to judge. And I think that's where the discretion is going to come in. And the issue on appeal to the 11th Circuit is going to be, does the 11th Circuit agree with the judge that no reasonable juror could find in such a way? And I see cases where the 11th Circuit has disagreed with the district court judge on that point.
Judge Phillips?
Yes, I see that Diana Santa Maria asked another question. How does the new rule deal with video evidence? Example, where there is a video evidence of a crash or occurrence and it is submitted as evidence of negligence for summary judgment purposes. I think that's right on direct point, because I think that's where this all started and how we got here today from the Wilson, Art versus Lopez case, where that's exactly what happened. There was a motion for summary judgment filed on behalf of the defendant that had a dash cam or somebody neighboring, somebody in the neighborhood or somebody had the video evidence of the accident happening. And you could see it with your own two eyes, exactly how the accident occurred. And on the eve of that summary judgment being heard, the plaintiff filed an affidavit on behalf of a witness that was completely contrary to what you would see with your own two eyes on that video. However, under the old rule, there was a scintilla of evidence and the motion for summary judgment was denied. And essentially, that's how we ended up here today. So I think video evidence is very important, and it'll be important in the future.
So can I just add one thing about that case?
Yeah, of course.
So I was involved on the amicus level with the Wilson R case, and you described it perfectly. But what was interesting about that case is there actually was a second video, which the plaintiff, the non-moving party there, did not present at the trial level. And the plaintiff also didn't present deposition testimony of an expert. The plaintiff only submitted his I don't know if it was he or her, his expert's affidavit in opposing the motion for summary judgment. The deposition actually occurred after the summary judgment hearing. And so that case, which got, you know, the 5th District, which reviewed it, just as Judge Phillips said, we have an expert's affidavit here, which they didn't have the testimony, which is wholly contradicted by what we see with our own plain eyes in the one video they had. And that's where the 5th District certified a question of great public importance to the Supreme Court, which we saw yesterday in the Supreme Court's opinion, Florida Supreme, they cited back to a US Supreme Court case, Scott versus Harris, which is this notion is that when the record blatantly contradicts you know, submitted affidavit, submitted deposition, we or I as a trial judge, I can disregard the party's version of what the events are with video evidence. And so that case, the Wilson R case, just it shows the degree, and I think hopefully everybody will understand it with the new rule, that the non-moving party in state court, like federal court, you've got to show all of your guns. You can't sit back. We know the timing is one thing, but it's also, you need to get all of your discovery and you need to cite it for the judge who's sitting and overseeing your case, or you're going to lose your right. You know, you're going to lose your right to a jury. You know, you've deprived yourself and your own client of the otherwise constitutional right to a jury trial. And so that case there presents an example of where under the new rule, where summary judgment could have been granted based on what the state circuit court judge had in front of him or her at the time.
All right, we're
as often said, you're not in Kansas anymore.
That was it. The perfect summation, Judge Levinson. I want to, it looks like we're running out of time. So I want to just go ahead, take a moment to thank our wonderful panelists, Judge Singhal, Judge Phillips, Judge Levinson, Judge Kashi. Kashi.
Congratulations, Joe.
All right. Andy Harris, and special appearance by Judge Rodriguez. I want to thank the other judges who are in attendance, Judge Perlman, Judge Frink, Judge Green, Judge Peter Weinstein, Judge Luzzo. In addition, we had Diana Santamaria from our Board of Governors. We had our national president of ABOTA, Grace Weatherby, was on. Thank you guys all for being here, and we absolutely appreciate everyone who attended. Again, I hope everyone will join us on the 3rd for our next installment of the changing procedures as the courts are reopening for our case management directives program with Judge Tudor, Judge Phillips, Judge Lee, to discuss the new administrative order, which again can be found on abotaftl.org. So thank you everyone for spending your lunch hour with us, and we appreciate you joining.
And real quick before we go, I saw in the chat, congratulations to Jeff Adelman, FLABOTA President, Incoming President 2023. Excellent.
Well, thank you.
Congratulations.
Thank you. It was a terrific surprise when I got the call. So I'm very excited. get involved with the executive for ABOTA.
We had Judge Frank with us. Thank you for joining us as well. Let's see him. All right. Thank you, guys. Have a fantastic weekend. And I appreciate everyone being here.
Thanks for the memories.
Thank you, thanks so much.
Thank you. Thank you, Brent. Excellent job.
Thank you.
Thank you.
Thank you, thank you, Judge Singhal, for all you do.
You, always
Please.
good to see
Great to see you. Great to see everyone. Have a great weekend.
Thank you. Thank you, Anna.
you.